All right, ladies and gentlemen, there was a second hearing in HYBE's lawsuits against Min Hee-jin on April 17th. Now, I know I have covered multiple NewJeans related issues this week, and I know you guys are tired. I am tired too. And if this was anything just ordinary NewJeans related, another NewJeans related stuff, I would have delayed it because I have a list of other HYBE related and K-pop related stuff that are worth making videos about. But this one is about Min Hee-jin, the one behind the whole thing that happened last year and continue on this year as well. The one who had just pure evil intentions in the very beginning, from the very beginning, before NewJeans was even formed, at least in 2021, if not before, who had plans to snatch away NewJeans from Source Music and HYBE, and who thought about teaming up with another party to take over Bang Si-hyuk's company, and who made plans to end BTS and end HYBE and Bang Si-hyuk when BTS is away in the military service, for the military service, when HYBE is at its weakest. So, I feel like a lot of people have put focus on NewJeans lately, especially after the whole injunction case. And I mean, yeah, since the middle of last year, Min Hee-jin was gone from the whole scene, and she put NewJeans up front. And the public attention was on the group and the members. And I think that was part of her strategy, which is why, I have to cover this issue at some point, right? Now, when it comes to the second hearing, there wasn't a lot of new information that came out. There was some interesting information. So I'm going to cover this with some details and references. So this video that you're watching is in 3 parts. First part, we're going to read this article. I think this one is the most comprehensive. And then I will, do some analysis and simple interpretation. And then secondly, Min Hee-jin came up with her statement yesterday through Sejong Law Firm. So we're going to talk about that and try to see, where she's getting at through this statement and an analysis. And in part 3, we're going to talk about HYBE's grounds for terminating Min Hee-jin's contract in the first place, because that's at the center of this lawsuit. Okay, so and then of course, as always, I came up with these screenshots, graphics, and evidence, receipts, and stuff. So yeah, let's start with this article. I'll do the translation. Released by TV Daily at around 3 p.m. in the afternoon on April 17th. Title is HYBE versus Min Hee-jin. Both sides agree on contract termination, but the fight over who's to blame continues. So that basically sums up the current status, right? The issue is, who is to blame for the termination of the contract? And that matters, because whether HYBE pays a lot of money to Min Hee-jin for her, let's go over this first, and then we'll talk about it one by one. HYBE and former Adore CEO Min Hee-jin have reached common ground on one point. The shareholders' agreement between them has been terminated. However, a legal battle continues over which party was at fault for the termination, a question that could affect the validity of put option and call option tied to the agreement. Yeah, that's what I was just trying to say. On the afternoon of the 17th, April 17th, the Seoul Central District Court, Civil Division 31, held a second hearing in HYBE's lawsuits against Min Hee-jin and another party, and that one they're referring to Shin Dong-woo, okay, who was the former deputy CEO of Adore. Another party, Min Hee-jin and another party, seeking confirmation that the shareholders' agreement had been legally terminated. Because this is a civil case, 민사, there is no requirement for either party to appear in person, and Min Hee-jin did not attend. Well, in fact, she never appeared in court, even though NewJeans members themselves appeared in person for the injunction case, right? However, around 10 attorneys from both sides were present in court. Both sides stated they are not disputing the fact that the agreement has been terminated. Good. But they emphasized that it's still necessary to determine who was at fault for that termination. They also noted that additional legal issues remain, including a separate lawsuit filed by Min Hee-jin in November 2024 to claim payment from exercising her put option. And we're going to talk about the meaning of put option and call option because it could be like technically difficult. For exercising her put option and HYBE's formal notice that it would exercise its call option. These issues, both parties agreed, should be resolved through further litigation. Min Hee-jin's legal team, Sejong Law Firm, explained that their lawsuit over the put option payment is based on the premise that HYBE's notice to terminate the agreements on July 8, 2024 was not effective at the time. They added that a later suit filed in November assumes the contract had been terminated but still sought enforcement of the put option. Both sides continue to argue that the contract was terminated due to the other party's fault. HYBE claims Min Hee-jin violated the agreement, while Min Hee-jin claims HYBE failed to correct its own breaches. Both maintain that the termination was valid, but for different reasons, and with very different implications. HYBE has also claimed that it exercises call option, which allows the company to buy back Min Hee-jin's shares. They say the contract explicitly allows them to do this regardless of whether the agreement has been terminated. While HYBE has not yet filed a lawsuit to enforce this call option, and this is a pretty interesting point, it emphasized that it may pursue legal action in the future, especially since this right is tied to the question of which party is at fault. HYBE further argued that since Min Hee-jin has already filed suit demanding payment based on her put option, HYBE must be allowed to confirm whether the option is even valid under the current circumstances. In response, the court decided to conduct joint proceedings for both the contract termination case and the put option payment suit, given the overlap in factual and legal issues. The next hearing is scheduled for June 12, 2025. Now, when the court requested both parties to clarify their core arguments in writing, this is interesting, and this is one of the reasons why Min Hee-jin came up with her statements later in the evening. When the court requested both parties to clarify their core arguments in writing, Min Hee-jin's team replied, "This is fundamentally a case of where the burden of proof lies with the plaintiff, that is, HYBE. So once HYBE submits its summary, we will respond accordingly." HYBE countered that Min Hee-jin's side had not yet submitted any rebuttal documents, stating that without knowing how they are going to respond, we can't move forward with our detailed arguments. The court concluded the session by saying, "Let's continue this through written exchanges, and set the next hearing date, which is once again June 12th, 2025. As it stands, both HYBE and Min Hee-jin acknowledge that the shareholders agreement has been terminated. HYBE gave notice in July 2024, and later Min Hee-jin later confirmed the termination herself when she resigned from her board position at the door in November. However, they continue to blame each other for breaching the contract, which could be a deciding factor in the disputes over options and payouts. So in this part, the writer, this journalist is summarizing, and explaining some context, right? One of the key terms in the original shareholders agreement was the 5-year guarantee of Min Hee-jin's CEO and board roles, along with her put option, which allows her to sell shares back to HYBE under set conditions. That put option allowed Min Hee-jin to request that HYBE buy her shares based on the company's average operating profit from the 2 years prior, multiplied by 13, then multiplied again by 75%, which is her partial shareholding. If the calculation uses 2022, a 4 billion Korean won loss, and 2023, a 33.5 billion Korean won profit, the estimated payout would be around 26 billion Korean won, 260억 won. HYBE, however, argues that the contract on which the put option is based was already terminated due to Min Hee-jin's breach of trust, and therefore the option is no longer valid. Min Hee-jin's legal team maintains that the termination occurred improperly, and they are seeking a court ruling to affirm the validity of her claim. So thank you to the journalist Kim Ji-ah from TV Daily for writing out this article. So let's go over this issue because it could be kind of complicated. So here's a summary. The current status. Both sides, Min Hee-jin and HYBE and Min Hee-jin, agree that the agreement, shareholders agreement, has been terminated. Now, the key issue is about who was at fault for the termination of the contract, which is a critical factor that directly impacts whether each side can exercise their put option or call option. Okay. Now, can Min Hee-jin exercise her put option? So in November last year, Min Hee-jin notified HYBE that she was exercising her put option on 13.5% of her Adore shares. HYBE, on the other end, claims the agreement was already terminated back in July. So, therefore, her right to sell those shares is no longer valid. Min Hee-jin argues that the contract was still in effect at the time, and she met the necessary conditions, meaning that HYBE owes her around 26 billion Korean won, which is a calculation that this journalist came up with. And I've kind of talked about this calculation last year on my channel. And interestingly, if she waited for a few more weeks, she technically could have been paid more because it is 2 years worth, right? And it could have been like 2023 and 2024 when NewJeans made more money. Remember, 2022, they made a loss. So it was kind of interesting. Why did she rush? And that was probably part of her strategy to have a chance at getting paid. But we'll have to see whether she succeeds or not. So that's the put option formula. Average operating profit for 2 years, 2022, 2023. And times 13, the multiples, and times 75% of her total shares. And that's equal to around 26 billion Korean won. Now, what about HYBE's call option? I'm gonna, simplify this a bit more later on. But after Min Hee-jin exercised the put option, HYBE responded by claiming that it had already exercised its call option, which is the right to buy her shares. Maybe if you're an investor, you know these technical terms better, right? Now, no legal action on HYBE's part has been filed yet based on this, but they may use it as a strategic defense later, meaning they have only declared it, right? But they're not pushing it forward to actually buy her shares. According to HYBE, the call option remains valid regardless of whether the agreement was terminated or not, according to the agreement, according to the contract, based on the original contract terms. So, the issue is who is to blame, right? According to HYBE, Min Hee-jin tried to seize control of Adore. That gave them grounds to terminate the contract legitimately. So this forms the basis of their argument that her put option is invalid. And in part 3 of the video, I'm gonna lay out the reasons that they have talked about why such contract termination is valid. Okay. Now, Min Hee-jin's side says this: HYBE is the one who breached the agreement. The contract was still valid when I exercised the option. Therefore, her put option claim is legitimate. Now, the court, decided to merge the two lawsuits, the one about the contract termination and the other about the put option payouts. So that's what the merging means. And the next hearing, because things are quite related, and it's more effective to handle the two lawsuit cases together. The next hearing is scheduled for June 12, 2025, and both parties have been asked to submit written summaries of their positions. And there was a interesting conflict clash about that. And then we'll talk more about this in part 2 when we talk about Min Hee-jin's statements that came out later in the evening. Now, let's go over some technical terms that could be kind of confusing. So shareholder agreements, why does it matter? It's not quite like a regular contract because a shareholders agreement is a private contract between an investor, that is HYBE, and an executive, Min Hee-jin, that outlines how shares, responsibilities, and control are handled. And it's not just ordinary employment contracts. It's a type of investment deal, which makes it more complex as less publicly transparent. Okay. What about the difference between a put option and call option? This could be a bit confusing. Put option is Min Hee-jin can force HYBE to buy her shares if she wants to sell. On the other hand, call option, by call option, we mean HYBE can force Min Hee-jin to sell her shares if they choose to buy, right? So it's important to understand this part to understand what's going on, between HYBE and Min Hee-jin at the current stage. So when does a contract termination actually take effect? Although NewJeans members are saying that they can simply state that, oh, now our contract is over. But that's not how it works. Not exactly. For a termination to be legally valid, certain conditions have to be met. And most importantly, who is at fault? And by that, breach or cause determines whether the termination and the follow claims will hold up, like put option or call option, right? Min Hee-jin says that HYBE didn't have valid grounds to end the contract. On the other hand, HYBE says that Min Hee-jin violated the agreement first, so their termination was justified. And yeah, we talked about this, right? Consolidated trial, the merging. The court decided to combine or merge the shareholder agreement case and the put option payment case into one trial because the facts and the legal issues are closely connected. Handling them together saves time and avoids confusion. And next hearing will happen on June 12th, right? If I remember correctly. And let's go over this call option one more time because we talked about Min Hee-jin's put option last year, but not really talked about call option. So why is this suddenly important? Min Hee-jin first said that she wants to sell her shares to HYBE, that is put option, and in response, HYBE pulled out their own right, the call option, which allows them to buy her shares before she can sell them, right? HYBE says that the contract includes a call option clause, and according to them, this right can be exercised regardless of whether the agreement has been terminated. Now, they haven't filed a lawsuit based on it yet, but they're keeping it as a legal counter move that's ready to use if needed. So HYBE says it has exercised the call option, but hasn't filed a lawsuit to enforce it yet. They also say whether the call option is valid depends on who was at fault for the contract termination. That is, who breached the contract. In simple terms, HYBE officially informed Min Hee-jin that it's exercising its call option, meaning it wants to buy her shares under the contract terms, but it hasn't yet filed a lawsuit to legally enforce the action yet. In other words, they've drawn the sword but haven't swung it yet, right? They haven't followed through with concrete action to buy the shares. And then we talked about this. Now, HYBE claims that the contract says the call option can be exercised regardless of termination, but it's not. It's not that simple. If the contract was terminated because HYBE was at fault, then that could affect whether the call option is still valid. So the validity of the call option is tied to the blame game over the contract breach. Who is at fault? Who did wrong? So here's a core issue. HYBE is trying to build a structure where it can say, we exercise the call option first, so Min Hee-jin's put option is invalid. But once again, whether that claim holds depends on who breached the contract first and whether HYBE's call option was exercised properly and at the right time. So yeah, that's what they're referring to when HYBE says the call option is connected to fault, right? And if you think about their potential strategy from their perspective, the call option is not necessarily an offensive move. It's more of a defensive tactic, I think, right? So it goes something like, the strategy goes something like, since we already exercised the call option, Min Hee-jin can come in later and claim her put option is valid, right? So they're using the call option to try to neutralize her claim. Now, whether HYBE will actually buy the shares is something they may decide later, depending on how the court rules, how Min Hee-jin responds, how the public reacts, or what financial terms are at stake. To be honest, at the current stage, Adore value, the value of Adore and Min Hee-jin is going down, right? Because Min Hee-jin, did I say Min Hee-jin? No, NewJeans. The value of NewJeans is going down because they're not doing activities, their public image and brand have been damaged because of their, strange behaviors. So we'll have to see whether they will actually buy her shares. But yeah, it's up to them. But they're leaving the door open to execute the option only if and when it works in their favor, right? So bottom line is, HYBE has officially said, we will buy, but whether they will really buy is still undecided. They have drawn the weapon, drawn the sword, but it's unclear if they will swing it. But of course, Min Hee-jin, on the other hand, made a clear move by saying that, buy my shares. You have to buy my shares. But HYBE countered with, we had the right to buy them first. So what we're watching right now is a battle over who drew first and whether the weapons they pulled are legally valid. So that was part one, and we're gonna talk about part two, Min Hee-jin's statements. But before that, as you can see, this matter is very closely tied to money, right? But interestingly, last year, Min Hee-jin has said repeatedly that she doesn't care about money. So what I pulled up was an article from September of 2024, also released by TV Daily, another journalist who has pointed out this. I don't care about money or titles. As long as I can produce NewJeans, that's all I need. This was the message Min Hee-jin repeated multiple times across two separate press conferences. But now, after being removed from her CEO position at Adore, her actions appear to contradict those earlier statements, leaving the public confused. At the first emergency press conference in April, Min Hee-jin said, NewJeans is what matters to me. I have no intention of taking over any company, and I don't care if someone else becomes the CEO of Adore. I don't need to be the owner. I just want to do the work I've been doing with NewJeans. She made it clear that producing the group was her priority, not holding on to her title. She echoed the same sentiment during the second press conference in May, saying, this conflict was never about money or status. That's still true. The only issue is the non-compete clause. If that toxic clause is removed, I'm open to compromise. Again, she emphasized that her only real concern was continuing to produce NewJeans, and that financial or positional gain wasn't part of the dispute. But after being officially removed as CEO, her stance shifted in ways that raised questions. In July, HYBE terminated its shareholder agreement with Min Hee-jin and waived the non-compete clause. effectively allowing her to stay on as a producer and internal director for NewJeans. Now, at the time, a lot of people were like, what is HYBE thinking? Why allow that, some call her witch. Why allow her witch to remain as an internal director and even producer? Why do they allow her to stay at HYBE? But the thing is, so in other words, everything Min Hee-jin had claimed to want during both press conferences was granted. But very interestingly, and yet, Min Hee-jin now argues that the shareholder agreement she once called a slave contract is still in effect and is actively pursuing a 100 billion won payout through a put option she insists remains valid. Now it turns out that the actual payout amount could be less than that, around 26 billion, the previous article said, right? This stark contrast between her past words and current actions has left many observers wondering what her true intentions really are, right? So this journalist is basically criticizing her hypocrisy, right? So that was the excerpt that I pulled out from this article from September of 2024. So it just shows that unlike what she said during press conferences publicly, she still cares about money. So what does she mean when she says that I don't care about money or titles? Because it clearly shows that she does care. All right, so now let's talk about Min Hee-jin's statements. Once again, later in the evening on April 17th, Sejong Law Firm made a statement, and that's the word spread through the Korean media. Okay, so let's read the statement together. Official statement from Min Hee-jin's legal representative. Hello, this is Sejong, legal counsel representing Ms. Min Hee-jin. This statement pertains to the ongoing lawsuit at the Seoul Central District Court. Now, this is interesting. They've indicated the actual case number. I've never seen something like that. Case number 2024 Kpop 80024, in which HYBE is a plaintiff and Ms. Min Hee-jin is a defendant regarding the confirmation of termination of the shareholders agreements. So it almost seems like they're basically telling the people, hey, here's a case number. Go over to the Korean court websites and enter the case number so you can verify what we're talking about. So that was a pretty interesting move. We have already submitted 2 written briefs rebutting the legitimacy of the termination reasons claimed by HYBE. In contrast, HYBE has yet to respond to our arguments, particularly concerning the invalidity of their termination notice, which we previously raised. HYBE submitted 3 additional documents on April 11th, 14th, and 15th, less than a week before the hearing on April 17th. We plan to submit our written response to these in due course. We would like to emphasize that the burden of proof in this case lies with HYBE. That is, HYBE must prove that the shareholders' agreement was rightfully terminated based on their notice. HYBE has made statements suggesting they cannot present further arguments unless we first submit a rebuttal. This is a misrepresentation of the principles of civil litigation. In civil cases, the plaintiff bears the burden of proof regardless of whether the defendant responds or not. We ask that HYBE acknowledge this basic legal principle. Thank you. Sincerely, Sejong LLC. What do you think? I think this is another example of typical Min Hee-jin's public opinion warfare. Because why make the statement through the media and spread it through the media? Why not, say it in court? And yeah, it smells like Min Hee-jin. So let's actually talk about their tactics, potential tactics behind making this statement. First of all, let's review what happened in court, especially the latter part of this article that we read in part 1. The judge asked both parties, HYBE and Min Hee-jin, to summarize the core issues to speed up proceedings. Min Hee-jin's side, Sejong, responded, the burden of proof is on HYBE, so they should go first. On the other hand, HYBE and Kim In-jung push back. Like, how are we supposed to summarize anything when Min Hee-jin's side hasn't even filed a proper rebuttal? So what started as a procedural request turned into a standoff. Who should move first and who carries the legal burden? Now, what Min Hee-jin's official statement is trying to do. So first of all, is by doubling down on HYBE must prove their claims, the statement tries to spin the courtroom exchange as HYBE blaming others while failing to present solid evidence themselves. So it's reinforcing the legal burden angle. And secondly, maybe reframing the narrative on court rulings. Because in court, HYBE said that Min Hee-jin hasn't even filed a rebuttal. Her side now counters, we already submitted 2 statements. It's HYBE that hasn't responded properly. And third, they're subtly pressuring the judge via the media. Maybe that's their tactic. By publicly claiming HYBE is dodging its responsibilities, Min Hee-jin's side sends, maybe they're sending a message not just to the press, but indirectly to the court. Like HYBE's argument lacks substance. Now, if we were to, analyze this tactic more critically, so on the surface, it seems to be about like legal principles, but more is about like deflecting responsibility because Min Hee-jin's side keeps emphasizing the burden of proof is on HYBE. Now, this is technically true in a civil case, but this comes off less like a legal position and more like a way of saying we don't have to respond to anything. Yes, plaintiffs typically bear the burden of proof, and in this case, plaintiff is HYBE, right? But in reality, if the defendant doesn't submit a rebuttal, the court may treat it as a tacit acceptance, right? So that could be the risk. And Min Hee-jin's side keeps saying that we already submitted 2 written responses, but they don't explain, what they argued in those responses and what they refuted or how they refuted. So it feels more like they're trying to look prepared without actually engaging with the core issues. Now, HYBE submitted their briefs late. That part was interesting, but so what? What did they say? Min Hee-jin lawyers are pointing out that HYBE submitted 3 briefs just before the hearing on April 11th, 14th, and 15th. Less than a week before the hearing on April 17th. And yeah, if you go over to the website, southkoreancourt.go.kr, you can see these dates. And April 11th, 14th, and 15th, HYBE side, Kim In-jung submitted documents, right? So they're essentially saying that, HYBE submitted their briefs late. But so what? As long as they were submitted within the allowed schedule, there's nothing irregular or wrong about that. If anything, it could actually mean that HYBE was working until the last moment to strengthen their case. And perhaps they're trying to flip the narrative, like we are calm, we are ready, we are prepared. HYBE, on the other hand, is panicking. They're not ready. So by framing HYBE's filings as rushed, Min Hee-jin's legal team is perhaps, seems to be shaping an image, not a legal argument. They're nudging the public to believe that HYBE is scrambling to fix their weak case, even if that's not supported by the facts. What else? So that statement that Min Hee-jin and Sejong law firm came up with avoids addressing the core issues head on. The validity of the put option, who's actually at fault, and whether contract termination was justified. It's like a passive stance that looks more like a delay tactic than a real legal defense. And more than anything, it reads like a move aimed at public perception, not the courtroom, which is why I said, typical Min Hee-jin style press warfare or public opinion warfare, right? Yeah. So that's. But I don't know. Maybe they have some tactics or strategies that I'm not aware of. So if you have other opinions or other ideas, please feel free to fill in the gap by writing comments. All right. Now, yeah. So that was part 2. And now, let's move over to part 3. Now, anything else to add here? So, maybe this is a smart PR, maybe it's not. But from a legal standpoint, this statement looks more like a focus on procedural optics rather than tackling the real issues head on, right? And yeah, it's kind of funny. All right, so let's talk about part 3. So what comes down to is who is at fault, right? And here's an interesting article from October of last year, 2024, during the first hearing for the case between Min Hee-jin and HYBE. Now, Min Hee-jin's side also came up with their own statements, reasonings, and claims, but as we have seen, NewJeans lost to Adore, in the latest injunction case, right? 11-0. So the chances are, whatever Min Hee-jin's side claimed about, they wouldn't be that useful because the court already decided that they're not reasonable enough for the contract termination. Although the judges are different for these different cases, but chances are, the Min Hee-jin's reasoning would not work out in court because we now have a precedent. Unless they have some groundbreaking evidence that has been collected, maybe thanks to bunnies, detective bunnies, but we'll have to see. So it's really up to HYBE what kinds of evidence and receipts that they have presented to court to argue that their contract termination is valid. So we're going to review what they have claimed last year, which is why I came up with this article from October. So let's read this part. HYBE claimed that former Adore CEO Min Hee-jin and former Deputy CEO Lee Sang-woo had been plotting to seize control of the company for months, well before HYBE initiated its internal audit. So I'm gonna read this portion, and then I'll do the review of what was presented and with the actual screenshots as receipts. Okay. According to HYBE, Lee Sang-woo, who previously worked at HYBE, spent his entire 3 months at Adore focused solely on takeover-related tasks. Even before officially joining Adore, he reportedly met with the head of a capital firm to discuss a potential spin-off under the guise of preparing for an IPO, and later reported the conversation to Min Hee-jin. HYBE also revealed a message in which Min Hee-jin allegedly told Lee. Lee told Min Hee-jin, "We have about a year before BTS returns. The goal is to make things hard for them and win our freedom." HYBE further stated that Min Hee-jin instructed the original article was right. Min Hee-jin told Lee, "We have about a year before BTS returns. The goal is to make things hard for them and win our freedom." HYBE further stated that Min Hee-jin instructed the creation of a so-called 1945 report, which detailed potential attack points against HYBE executives, ranging from raising issues like chart manipulation and filing complaints with the Fair Trade Commission to estimating the damages if NewJeans were to terminate their exclusive contract. The report also listed potential investors and suggested using major shareholders like Dunamu and Naver to pressure HYBE into selling or buying Adore's shares. Naver is one of the largest platform companies in Korea, and Dunamu is the owner of the biggest crypto trading platform in Korea, and they're like a blockchain related company. HYBE argued that Min Hee-jin's independence strategy hinged on orchestrating a public opinion campaign to pressure HYBE and raise the chances of Adore being spun off, using NewJeans as leverage. They also presented a specific exchange from March 14th, where Lee asked Min Hee-jin, the former VP, asked Min Hee-jin how a recent investor meeting went, and Min Hee-jin allegedly replied, "The general consensus is that we should take NewJeans out. Let's take a closer look at the terms of their contract." During the court hearing, HYBE also disclosed that Min Hee-jin's side had leaked the full shareholder agreement to a major business media outlet. They pointed out that the agreement contains strict confidentiality clauses prohibiting disclosure to the public or media, unless both parties agree in advance on what and when to release. This, HYBE emphasized, constitutes a clear breach and grounds for termination of the agreement. Additionally, HYBE cited Min Hee-jin's mishandling of a sexual harassment case involving Lee as one of the reasons for her dismissal. When the first report came in, Min Hee-jin reportedly insisted that rules should be added to punish false accusers, and she shared details of the investigation with Lee without authorization. HYBE stated that Min Hee-jin repeatedly issued public statements framing her personal views as Adore's official stance and distributed these statements to the press via a PR agency she personally hired, probably a McCall consulting firm, which is an abuse of her authority. HYBE concluded that this pattern of behavior not only damaged the image of Adore and NewJeans, but also made Min Hee-jin's removal as CEO unavoidable. So that's a lot of grounds, right, for the contract termination. So they're not lacking evidence, so to say. So let's go over HYBE's position. Key grounds for terminating Min Hee-jin's contract. Alleged plot to seize control of Adore, and that's probably the most important part. HYBE claims that Min Hee-jin and former deputy Lee Sang-woo spent several months orchestrating a plan to take over Adore and operate independently, although she made this plan at least back from 2021. But the plan got more specific and got more real in 2024 and 2023, probably. Lee reportedly did no actual work during his 3-month tenure at Adore and was solely focused on the independence plan. There's also evidence he met with external investors and discussed IPO-based spin-off strategies before joining Adore that reported back to Min, and Naver and Dunamu being two of the potential investors that he met with. So from HYBE's perspective, Min Hee-jin used her insider positions and company resources to act against her parent company. And this is a breach of trust and loyalty, which HYBE sees as a clear violation of the contract. And here's a screenshot of the conversation between Min Hee-jin and the former vice deputy of Adore, Lee Sang-woo, right? How they're preparing to meet with key players like analysts or reporters or investors or potential competitors and institutions so that they can make this plan more concrete. And targeting HYBE during BTS absence. A message from Min Hee-jin reportedly said, "We have 1 year before BTS returns. The goal is to make things hard for them and earn our freedom." And from HYBE's perspective, and from our perspective, from perspective of BTS fans, this is a calculated plan to exploit HYBE's temporary vulnerability during BTS military hiatus. And this could be seen as deliberate disruption and hostile intent toward the parent company. Here you go, 1 year before BTS returns. And I have shown you similar screenshots in the very beginning, right? You need to end BTS here. Be determined every single day. February 4th, 2024, 1 year before BTS returns from military service. This is when HYBE is at its weakest. We end HYBE and Bang Xiao at this time. What an evil intention and plan. How about this? The 1945 report. Min Hee-jin allegedly instructed the drafting of the documents outlining strategies to pressure HYBE executives, including whistleblowing to regulators, raising chart manipulation claims, simulating contract termination penalties for NewJeans, and compiling a list of investors who could pressure HYBE through stock maneuvers. And this could be seen as a coordinated campaign using internal resources for external pressure. It goes far beyond ordinary duties, so this could be grounds for dismissal and contract termination. And here's an example, the portion of the 1945 document that HYBE revealed last year. Next, weaponizing public opinion and artists. HYBE disclosed a conversation where Min Hee-jin said the general opinion is that we should take NewJeans out and suggested reviewing their contract terms. So here's a conversation between Lee and Min Hee-jin. Lee asking, how was today's meeting? And meeting with potential investors. And Min Hee-jin said that something like, yeah, I think we could check them out again. And said something like, the general agreement consensus is that we should take NewJeans out and we should look at the contract terms more closely. So attempting to use artists as leverage to force HYBE to sell or spin off Adore. Again, this is a breach of fiduciary duty and a clear attempt to destabilize the company from within. How about leaking the shareholders agreement? We've kind of talked about this last year on my channel. So a full version of the shareholders agreements between Min Hee-jin and HYBE was published by a business outlet, a major media company, media agency in Korea. And that agreement included strict confidentiality clauses prohibiting disclosure without mutual consent. Right here. And yeah, Min Hee-jin or someone from her side leaked the document or allowed it to be leaked. And this is an explicit breach of contract and a valid reason for termination. That media agency in question was 한국경제, Korean Economy. And yeah. There we go. Yeah. During the court hearing, HYBE also disclosed that Min Hee-jin's side had leaked the full shareholder agreement to a major business media outlet. They pointed out that the agreement contains strict confidentiality clauses prohibiting disclosure to the public or media unless both parties agree in advance on what and when to release. This, HYBE emphasized, constitutes a clear breach and grounds for termination of the agreement. So this is an actual, original contract copy that journalists Cha Jun-ho and Ha Ji-eun from 한국경제 somehow had access to. And this, we talked about this particular journalist, Ha Ji-eun, last year on my channel because she's the same one who revealed to the public that, the one who allegedly said to Honey, actually said to the staff member who said to her artist to ignore Honey was Eyelet's manager. Remember, that whole thing came up during NewJeans' guerrilla live stream when Honey said that, oh, one day I was at like a HYBE building and I came across HYBE artists and one of their staff members, manager, said to them to ignore me or ignore her. And at the time, she didn't really reveal the identity of the artist that she was talking about. But the next day, this journalist, Ha Ji-eun, made an article, released an article saying that it turns out, after investigation, we have figured out that it was actually Eyelet's manager, staff member. And interestingly, she was the same journalist who wrote this exclusive article containing the original copy of the shareholder agreement. Well, at the time, this article was heavily in favor of Min Hee-jin, and its intention was to criticize and attack HYBE. But it turns out this is now serving serve as a receipt that could act against Min Hee-jin. What about this? Mishandling of a sexual harassment case. Min Hee-jin reportedly dismissed early complaints against Lee Sang-woo, raised by, the former employee of Adore that we have talked about multiple times last year and this year, proposed punishing false accuser and shared investigation materials with the alleged perpetrator, Lee Sang-woo. She then made her personal statements to the press, framing them as Adore's official stance via a PR agency she hired herself. From HYBE's perspective, it's an unauthorized unilateral communication and ethical breaches. So that could damage the public image of Adore and potentially NewJeans, undermining her position as CEO. And this is a screen capture of a conversation between Min Hee-jin and Lee Sang-woo that was revealed by Dispatch, where Min Hee-jin is calling the former Adore employee names, calling her a psychopath, and then saying that, saying that the former employee would not be brave enough to sue either of them, right? Yeah. And it turns out that she made revisions for Lee Sang-woo's statement that he, document that he was supposed to submit to HYBE to explain the case. And then he actually took the revision word for word. And this has been revealed by the Korean media. So in summary, HYBE is framing its contract termination case around three core themes: breach of trust and attempted power grab, that's the most critical one, and direct violations of contract terms, especially regarding confidentiality, and unprofessional or damaging conduct that harmed Adore and its artist NewJeans. So HYBE is arguing that Min Hee-jin is no longer fit to lead Adore and that her behavior amounted to a serious violation of contractual obligations. And that was a type of argument that I'm assuming that they made during the first hearing last year in October. But since then, we now have some more revelations, right? Revealed by, media agencies such as Dispatch and 10 Asia. First, using artists as tools in media pressure campaign. Min Hee-jin is believed to have used NewJeans to drive public sentiment through a coordinated sequence of a live stream, guerrilla live stream, a National Assembly appearance, and a press conference. So it turns out, based on the Telegram conversation between Min Hee-jin and one of the parents of NewJeans members, she was behind, or she was at least aware of the guerrilla live stream where they said that it had nothing to do with Min Hee-jin, but it seems like she actually coordinated the whole thing. And even though Honey said that it was entirely her own decision to show up at the National Assembly audit, she actually met with Min Hee-jin and Sejong lawyer a day before Honey made an announcement through phoning the NewJeans communication app, fandom app, that she will speak at the National Assembly audit. So chances are she coordinated the whole public sentiment warfare, right? Although she claimed she had tried to stop them, evidence shows that she was fully aware of the live stream timing and had been in contact with the members' families. So it points to a calculated strategy using the group to push for her reinstatements. What about this? This is significant. Signs of tampering. Attempt to move NewJeans out of Adore. While still serving as an Adore executive, Min Hee-jin met with Park Jung-gyu, the de facto owner of Davolink, Davolink, and directly asked, "Do you think I can bring NewJeans with me?" And Dispatch has released these photos, right, receipts, to show that she met with the potential investor, that is the de facto owner of Davolink, and 10 Asia actually did an exclusive interview with him because he was angered for the fact that Min Hee-jin flat out denied the fact that they met, right? Which caused the company's stock price to plummet. So she directly asked, do you think I can bring NewJeans with me? She had also been in touch with investors via NewJeans members' family, discussing a possible exit plan. And discussing the transfer of artists during an active contract is tampering, and engaging in investment talks while employed could meet the legal threshold for breach of fiduciary duty. And according to Dispatch and Park Chung-gyu's own testimony, Min Hee-jin's actions weren't just speculative planning. Remember, like during the first press conference that Min Hee-jin pulled off, she said something like, "Oh, those things that I said in my private conversations, that was just jokes. I was just joking. I was just kidding." But she actually made moves, and those moves had already moved into the execution phase. Meeting with investors, negotiating possible control of a company, and planning to take artists with her, all while still in office. So these are not just red flags, they're actionable events. So, at least from my perspective, HYBE has a lot of evidence that they have mounted against Min Hee-jin for key grounds of terminating Min Hee-jin's contract, right? And if the court accepts these grounds, then the chances are Min Hee-jin's put option will be invalid, and HYBE call option would be valid on the other hand, right? So it seems to me they have an upper hand, but we'll have to see. We'll have to see. So that was that. All part 3. Part 1, we talked about the article, the second court hearing that happened on April 17th. Part 2, we talked about Min Hee-jin's statements and her potential tactics behind coming up with this statement. And part 3, we went over, HYBE's reasoning and evidence that they had against Min Hee-jin. So, yeah, feel free to discuss what you think about this whole thing. And once again, even though we're all tired about everything that has been happening, I cannot forget what Min Hee-jin has been doing and has done in the past as a HYBE shareholder and as a fan of HYBE artists. And even though a lot of people would be like, oh, this is just an old news, it's time to move on, I think this is too significant to just brush aside. So I will continue to cover this issue if there are updates, and I might make some, content to review what was revealed from last year, because there is just too much out there. All the evidence that that came up last year, that to the point that even people familiar with this whole case, one day, when they read stuff from last year, it could be like, what? How do I not remember this? And that happens to me too. So I think it might be a good time to review the case, especially because Min Hee-jin is trying so hard to hide behind NewJeans, right, for her own benefits. But I will remember for a long time that she was the one behind this whole shenanigan that has been happening from since last year, who had clearly evil intentions to take away NewJeans from HYBE and destroy HYBE, Bangshil, and BTS. Okay? Did I say this? And this is the last thing that I'm going to say. Some media outlets are portraying this legal battle between HYBE and Min Hee-jin as the battle of capital, battle of money, the battle between the haves, the wealthy, as if this is some sort of, I don't know, business warfare or something. But I feel like that's not being fair because, again, she clearly had evil intentions from at least 2021 to take away a project first initiated by Source Music, taking away the girl group, and then destroy HYBE, BTS, and Bang Xiao. So calling this like a capital warfare, involving lots of money. Involving lots of money, that part is true. The whole put option, call option thing. But I think, we need to acknowledge the fact that she had these types of twisted intentions from the very get-go. So with that, I'll wrap up. Maybe I'm being heavily biased against her, but sorry, I cannot help it. Once again, as a HYBE shareholder and as a fan of HYBE artists. All right, but once again, let me know what you think by leaving comments. And as always, when we do communicate, let's try to stay positive, respectful, and classy. Thank you guys. Peace and love. Bye-bye.